Okay, I'm going to get things started. Good afternoon, everyone, and thank you for logging on for this edition of our Trust Election webinar series on what comes after Calais. This webinar is hosted by the Center for Election Innovation and Research. My name is Joanie Greve, and I'm CEIR's communications lead. As many of you know, CEIR is a nonpartisan nonprofit that works with election officials at the state and local level from around the country and from both sides of the aisle. We seek to support elections that voters should and do trust. Today, we'll hear from David Becker, who is CEIR's executive director and founder. He has more than 25 years of experience in elections, having served as a senior attorney with the U.S. Department of Justice's voting section in both the Clinton and George W. Bush administrations. He also led the elections team at the Pew Charitable Trust prior to founding CEIR. You will also hear from Tamar Hagler, who is CEIR's new legal program director and the former voting section chief at the Justice Department, as well as Justin Levitt, former Deputy Assistant Attorney General in the DOJ's Civil Rights Division. I'll hand the conversation over to our speakers in just a moment, but first I'm going to cover a bit of housekeeping. Today's webinar is being recorded, and we'll make that recording available to you after we conclude today. We'll have some time for questions at the end of our speaker's discussion. At that point, I'll ask you to please use the Q&A box at the bottom of your screen to share your questions. You'll also be able to follow along and see any questions that have already been asked in the Q&A box, and we'll try to answer as many of your questions as possible. Thank you, and with that, I'll hand it over to David. David, over to you.
Thanks, Joni. And thank you all for joining us. We had such a great response to this webinar, and it's probably because of the two people that I'm fortunate enough to be joined by. So between the three of us, we've worked at the DOJ in the 90s, in the 2000s, in the 2010s, and in the 2020s. And the two people who've joined me for this webinar have more and better and more recent experience than I have, and I'm very pleased to be joining them. As you heard, Tamar Hagler has just joined CEIR as our legal program director. She'll be overseeing our legal work, and she has an incredibly distinguished career of a quarter of a century, even though she doesn't look it, having served in many of the sections of the Civil Rights Division, including as chief of the voting section. She's a former colleague of mine when I was working there. And then, of course, we're also joined by Professor Justin Levitt of Loyola Law School, who also served as Deputy Assistant AG in the Justice Department during the Obama administration. Correct, Justin? Yes. So between the three of us, hopefully we'll be able to give some context to this major decision that was released by the Supreme Court almost exactly 1 month ago today, back on April 29th, where the Supreme Court, I think it's fair to say, upended decades of precedent in how Section 2 of the Voting Rights Act can be applied to voting practices, including redistricting plans. And this follows, of course, a little more than a decade earlier in the Shelby County decision in 2013, when it upended decades of practice with regard to the application of Section 5 of the Voting Rights Act, leaving the Voting Rights Act, as we sit here today, a husk of its former self, unfortunately. So we want to go through a little bit about what the decision says, what it doesn't say, what that means for the future, and what can be done about it. So with that, Justin, I'm going to start with you because I think as the esteemed academic amongst us, the one person who was willing to wear a tie for the webinar. Why don't you explain for everyone who's listening, like, what does the Callais decision actually say? What is the standard that the court, in my view, created in the Callais decision? And then also, I think really importantly, and you were one of the first to raise this, I think, publicly, is what does the Callais decision not say? How is it kind of being mischaracterized by some out there to achieve partisan goals?
Yeah, thanks, David, and thanks very much to CEIR for hosting this webinar. I am also delighted to be here with you. I share your sentiment that the Callais decision was an act of creation or destruction rather than interpretation. It didn't so much try and figure out what a statute said as invent a new statute and substitute it in place. And it has, as you say, made the Voting Rights Act essentially a husk of itself, along with the Shelby County decision. There are three sort of major impacts that Callais has. It's effectively made it all but impossible to fight and win a Voting Rights Act case in any jurisdiction where the jurisdiction can consider partisanship. In part because it says you have to remove partisanship entirely from the conversation if you're going to make a Voting Rights Act claim in places that allow partisanship as an alternative explanation for lines. And that not only creates an incentive for parties to be as racist as possible to insulate themselves from Voting Rights Act liability, but as a practical matter, it's meant that in order to prove any case under the Voting Rights Act in a place where partisanship is allowed to operate, you're going to need to prove intentional discrimination effectively, and a constitutional claim is going to be easier to bring than a Voting Rights Act claim. So it's rendered the VRA a dead letter in jurisdictions effectively.
By the way, Justin, can I ask you a question about this? That point about rendering a constitutional claim easier than a Voting Rights Act claim, that's it's not that a constitutional claim is easy, right? It's actually very, very hard, which is one of the reasons the Voting Rights Act was so important, and that's why that's such a major change.
Yeah, that's exactly right. And it's backward from what the Congress intended in 1982, when it very explicitly said constitutional claims are too hard, so we're going to make the proof a little bit easier for Voting Rights Act claims. The court in Calais did exactly the opposite. If constitutional claims are a really tall mountain, the Voting Rights Act claim is now Everest. And it's going to be all but impossible to climb it in any normal case. You're going to need somebody to have slipped up on the record. And even then, the intentional claim under the Constitution is going to be easier. So you're not going to see Voting Rights Act claims, I suspect, in any case where partisanship is allowed in the jurisdiction. For district lines where partisanship is not allowed, and there are quite a few of those, in statewide claims in states that prohibit the consideration of partisanship or partisan gerrymandering, in local municipal races, where often the races themselves aren't partisan and don't feature partisan patterns, you might well be able to make a Voting Rights Act claim, but they're going to be really dramatically more difficult than they were. The court has ratcheted up the burden of proof and has, once again, tied the burden of proof under the Voting Rights Act much more closely to intentional discrimination than it's been tied in the past. And you're still going to see an awful lot of jurisdictions in that zone develop sudden affinity for purportedly race-neutral principles that just happen to coincide entirely with race and make those cases really difficult. And then there's a third category, where the Voting Rights Act might still have some real meat behind it, where it's not going to be quite as hard, even though it's still substantially difficult. These are local jurisdictions that are currently at-large jurisdictions, where the fight is over keeping the jurisdiction at large versus dividing it into districts or having some sort of alternative system. And it is possible that the Voting Rights Act will still be a real engine of change in those jurisdictions, even though it's still going to be harder than it was. The Calais court clearly wasn't thinking about that sort of case when it delivered this decision, and it might well have left some room on the margins. But the common theme in everything I've just said is it's going to be a lot harder to bring a Voting Rights Act claim now than it was before.
That's such a good point. And it always strikes me when we talk about some of these Supreme Court cases, they often revolve around congressional redistricting because the stakes are viewed as so high. And we forget that congressional districts are just a tiny minority of the districts that are actually affected by redistricting claims. I know, Tamar, you and I, when we were at the DOJ litigating these cases, I mean, it was rare actually to be engaged in kind of a statewide congressional redistricting plan. Or if it was statewide, it was just as likely, if not more so, to involve state Senate, state House kind of districts, those kinds of things. It's a really great point that we're even the court seems to kind of fallen victim to that in how they view these races. And Tamar, maybe we should talk. I want to talk a little bit about the standard that they created, Justin, and the standard. And you alluded to this that first of all, there has to be intentional racial discrimination. That was a bar that Congress had expressly rejected in when it renewed the Voting Rights Act in 1982, and then later on in 2006, and it kind of creates this safe harbor for partisanship. The more partisan you are, the more you're inoculated against claims of racial prejudice. And it strikes me it really just ignored the prevalence of what used to be the standard, which is very largely based on racially polarized voting. That the three of us have talked about this before. There's this impression of the Voting Rights Act that the Voting Rights Act just requires where there are black voters, they get a black district, and where there are white voters, they get a white district, and where there's Latino voters, they get a Latino district. And all three of us know that's that's furthest from the truth. Like it would have made our jobs incredibly easy as bringing cases as plaintiffs in those cases. Tamar, can you talk a little bit about that? About like kind of the standard that existed pre-Calais and what that meant for those of us who were bringing cases, whether they be private attorneys or the DOJ, in terms of what had to be proved and how it wasn't actually an easy standard at all.
Sure, absolutely. I'm happy to be here. One of the things I want to add to what Justin said about Calais, that as I read it, I at least thought it was notable, is that at each stage of the revised um, set of standards, at each stage of the jingles preconditions, the court really suggests that you have to be able to prove the end result, right? So if you don't prove this up the standard in Jingles 1 in the way that they now require it, then you haven't proved that the map is unlawful. But of course, the conclusion that the map was unlawful came at the end of the process, not at each stage. Otherwise, you probably would need multiple stages. And so that struck me, which leads me to your question, David, about how these cases have been proved. And anyone who's been anywhere near one of these cases knows how extensive of a litigation is required to prove up one of these cases. It's very expert heavy. And so, whether there is racially polarized voting is not a matter for those who haven't done this. It's not a matter of Tamar or David or Justin looking at the place and saying, it kind of seems like Black candidates lose most of the time, or don't really get as much support from white voters, or it seems like if they kind of move the line a little over here, Black candidates would do better. That is not how this works. It's an extremely sophisticated uh, uh, statistical analysis that can be done only by people who have expertise to be able to do it, and can be understood by some greater number of us, but probably not all of us, to a great degree. And so the ultimate point is that we always had to identify race as the driving factor. That's what a racially polarized voting and racial polarization analysis always did. So the suggestion that before Calais, we didn't really work hard to disentangle race and party or race and politics is just not true, because these very sophisticated analyses were designed, in fact, to do just that. Now, it's not always easy to do for reasons we can talk about later in terms of what comes next, but that was always part of the process.
Yeah, this is such a great point. And as we're digging into this, by the way, I just want to acknowledge I thank you all for being on. We have some very experienced election lawyers who are listening to this, and some former DOJ lawyers who know this at least as well as we do. I'm sure you're here to listen to Tamar and Justin and not me. Just thank you for joining. Like, I hope we're honoring your knowledge here as well. But this is a really complex analysis, and the plaintiffs and the DOJ had the burden of proof in a Section 2 case, right? So they had to present this analysis. I remember many times, to your point, Tamar, this was, and Justin, maybe you can comment on this as well. You had to look really hard to find places where to use the language that kind of the majority of the court used in Calais, where you tried to disentangle partisanship from race to the degree you could. And it wasn't just assumed that was disentangled. I mean, I can't think of a single case I was involved in where we didn't look that involved partisan races, where we didn't look at primaries to try to determine whether or not there was something that could be isolated from the Democrat versus Republican dynamic to look more at the white versus minority voter dynamic. And also, one of the other things we often looked at, it's often misunderstood that this protects the rights of minority candidates to get elected. It absolutely does not. Um, and 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 there were times when the candidate of choice of minority voters happened to not be a member of that same minority. It's not common, but it happens. And that's as relevant as electing a member of the same minority group. Justin, could you talk a little bit about that as we're trying to put this into context?
Yeah, so the caricature of the Voting Rights Act is, as you expressed it, David, is absolutely right. That you just look around for a large group of minority voters and you draw a district for them could not be, as you said, farther from the truth. The truth is that there were several things that you had to prove in order to make a Voting Rights Act claim. One, you had to make sure that there was a sizable minority group. Yes, that's the starting point, not the end point. You have to prove, never assume, that there are different voting patterns within that minority community and in the community at large. You had to prove, not assume, that the district lines were the things that made the difference, so that minority candidates, minority communities were getting outvoted if you didn't draw the lines in a certain way, and could have a reasonable opportunity if you did. And you had to prove and not assume that there was some tie to intentional discrimination, either in the present or the past, in perpetuating discrimination in order to win a case at the end of the day. The so-called Senate factors from the 1982 reauthorization of the Voting Rights Act that created a link between conditions that perpetuated discriminatory results and the current districts that people were seeking. All of those things made the Voting Rights Act incredibly data intensive, incredibly localized, and incredibly nuanced. If you waded into town with a stereotype, you were going to lose that case and lose it quickly. The Supreme Court, at every stage of those elements that I just laid out, at literally every stage, made the burden of proof harder, and in some instances, as I mentioned before, well nigh impossible. They demanded things that might sound potentially provable in the abstract, but in real cases on the ground are going to be impossible, including crediting jurisdictions with a proven history of racism for their ostensibly race-neutral justifications, including rabid partisanship.
Yeah.
You've got to extract that from any claim, which is emphatically not what Congress wanted, and effectively turns the, as you say, the burden of proof on its head. And what that's going to mean is an awful lot of districts that, well, an awful lot of plaintiffs looking for relief from discriminatory structures that aren't going to be able to prove their claims. The one thing I want to, just before we lose it, I also want to mention what Callais didn't do. There's a lot of chatter right now, just like there was after the Students for Fair Admission affirmative action education cases a couple of years ago. There's a lot of chatter right now that claims that any district that happens to respond to a minority community is at risk after Callais. And that is just not true. That's opportunism. You're hearing a lot of people who would love to redraw districts claiming that Callais shook up the world and now they have to redraw, and that's just not the case.
Yeah, just to put this into context, Tennessee didn't have to redraw its districts because of the Callais decision. It didn't have to carve the city of Memphis, a majority black city, into 3 different districts, which means that Memphis will likely have 0 representation in Congress. That is in no way, through any interpretation of the Alito opinion, required.
That's correct. They did it because they could and because they wanted to, not because they had to. The status quo before Callais is that when race predominated, when it subordinated all other considerations in the drawing of a district line, then you might maybe have a constitutional problem. But considering race, putting race in the mix and stirring, that's just fine under the Constitution. And that, despite a lot of sloppy language in the opinion itself, that remains the case. That is still true today. And so the vast majority of districts around the country that were relatively careful before Callais in considering race, but not exclusively, not predominantly, not majority. All of those districts shouldn't be touched by the Callais decision, but you're going to see a lot of very opportunistic incumbents trying to reframe partisan opportunistic behavior as required by the court, unjustifiably.
Yeah. We're literally seeing this right now. I mean, and then as governors and legislators in certain states are trying to argue that their extreme partisan mid-decade redistrictings are required by Calais, and they're just not prevented by Calais, which is different, right? They could wait till 2028. There's no rush to do this, and that's Tamar. Did you have anything to add on those points?
No, one related point to talking about what Calais said, or one of the many things that it got wrong. To read Calais, one would think that Section 2 claims and cases are running amok, right? So there's this talk about, well, if it were any other way than we conclude today, then everybody could just bring a Section 2 case, and it's not that hard because you would just say, really it's partisanship, but no, really it's race, at least in the South in these places. And for people who are interested in the numbers, I commend you to an amicus brief filed on behalf of the Voting Rights Initiative at the University of Michigan and Professor Alan Katz, but they really detail the not just the not very big number, but the significant drop. These cases have gone down as one would expect them to do. All right, the law worked, and times have changed, and the number of cases have declined. And I mean, just to throw out a number, it was, according to this analysis, 105 vote dilution claims between 1992 and 2001, which itself is not a particularly overwhelming number when you consider the number of civil rights claims in federal courts, to 48 between 2012 and 2021, and just 26 since 2022. And yes, we're mid-decade, but these cases tend to come earlier in the decade because of redistricting.
And those are all, that includes local jurisdictions, right? For people doing
Yes,
calculation,
that's all of it.
the 50, that's everywhere in the country. 10,000, 100,000 local jurisdictions included in that number.
And to your point about this impression of like this Voting Rights Act run amok with excessive numbers of cases, which is completely contrary to the facts, there was also on track in the courts challenges to Section 2's private right of action, where anyone outside the DOJ, people would bring a Section 2 case. That has been the practice accepted by even the Supreme Court for the entirety of the Voting Rights Act's existence. But that was being challenged recently, and the Supreme Court just sent, and Justin, correct me if I'm wrong about this, just sent back to that appellate court an order to review in light of Calais, which I found to be somewhat coy on their part.
Well, it's mystifying. And Justice Jackson, I think, dissented from that order. This is another shadow docket order. Well, it's not quite a shadow docket order. It's an unexplained single grant, vacate, and remand, where they accepted a case, vacated the decision below, and sent it back for further consideration. The case below said, as David suggested, that private plaintiffs don't have the authority to enforce the Voting Rights Act. That is, I can't think of a kinder way to put this, ludicrous as a matter of statutory interpretation. Every judge and justice thinks that the job in interpreting a statute is to do what the legislature would have wanted. Even the most textualist judges out there, even Justice Scalia, said, we look at the text because that's the best evidence of what the legislature would have wanted. And if you think for a hot second about 1965 or 1982 or 2006, to think that as Martin Luther King Jr. was looking over the shoulder of Lyndon Johnson signing the Voting Rights Act, that was meant to be enforced only by the Department of Justice and not by private plaintiffs like the NAACP Legal Defense Fund is absurd. And DOJ has repeatedly taken the position that the claim that private plaintiffs were meant to be fenced out from this thing is absurd. So that case comes out of the Eighth Circuit, which develops an absurd result, goes up to the Supreme Court. They send it back in light of Calais, ostensibly, but there's literally nothing in Calais that deals with that issue. Nothing, not word one.
Yeah, and there's nothing at all about the way the standard is changed in Calais that would in any way suggest, right? It's harder for everybody to bring these claims, but there's nothing to suggest that the way you now prove a case is within the unique orbit or ability of the Justice Department. This is really concerning.
It really
that
is.
they
I
did
mean,
that.
it again shows that, the Supreme Court is, the lower courts are sincerely looking to the Supreme Court for guidance here. I think the recent, just this week, the opinion in the Milligan case in Alabama that the three-judge court there issued by two Trump appointees, by the way, joined in. Basically, they did not thumb their nose at the court and the Calais decision. They diligently and deliberatively applied the standard that Justice Alito mentioned. I don't want to go in too much into that, although we're going to talk about that later. But it also strikes me that with regard to this private right of action and this impression that Section 2 is run amok, that how many of the Supreme Court cases, even those hostile to the Voting Rights Act, even those hostile to plaintiffs in the Voting Rights Act, were originated in cases that were brought by private plaintiffs, and the Supreme Court didn't like it could have easily said, sorry, you can't do this here. But for 60 years, they didn't do that. And maybe
Congress didn't change the statute
exactly
in response to this flood of private plaintiffs, which is in normal statutory interpretation how we tend to think that the courts are getting it right.
Which is a great transition to what I wanted to talk about next, which is kind of what the promise of the Voting Rights Act is and how it evolved over time. Because we were talking, Tamar, as you were talking about racially polarized voting, and Justin, you as well. I mean, it's not a bad thing where you can't find racially polarized voting. In fact, that's the promise of the Voting Rights Act. A lot of us have been involved in drawing maps or reviewing maps that have been drawn. And there are places where literally you can say, oh my gosh, you can't really prove racially polarized voting here. And not only can we not prove it, I don't think it exists. And that's wonderful. That means people are voting theoretically based on other factors, policies, and things that matter to them, but not on the color of the candidate's skin or the color of the voters who might support that candidate. That is wonderful. That's clearly not the current state of things in states like Louisiana and Alabama, as they've shown repeatedly. But if we go back to the Voting Rights Act of 1965, the multiple reauthorizations that occurred, and Justin, maybe you can take us through. I want to specifically get into what was happening in the 70s leading up to a case called Mobile versus Bolden, and then the subsequent 1982 reauthorization of the Voting Rights Act, which you started to allude to with the Senate factors, because I think that goes to the core of how this decision does not comport with the clear intent of Congress.
Yeah, and I think it might point us to the future as well. So it turns out the Voting Rights Act has been in a conversation between Congress and the courts from the get-go, in terms of what it covered, in terms of how it covered, in terms of the governing standard. Courts interpret, Congress says, we like some of that, we don't like some of that. Courts interpret again, Congress says, well, we're not sure about that particular part. There have been multiple attempts to reauthorize the Voting Rights Act and incorporate some of what Congress liked about what the courts have done and some of what it absolutely didn't. In the original Voting Rights Act was meant to deal with a number of cases. By the way, one of the ways in which there's been this dialogue is, does it apply to redistricting at all? And the courts, it was not entirely clear from the statute. The courts early on said, sure. And Congress said, yeah, we think that's right. They didn't amend the statute to correct that impression, part of this ongoing dialogue. So in the early iteration, most of the cases were about pretty blatant intentional discrimination. You didn't really need to develop the standard. In 1965, the cases were fairly clear as far as the evidence provided. That evolved, and as we started getting toward the end of the 60s and early 70s, constitutional claims began to assert not just intentional discrimination, but vote dilution that was adjacent to intentional discrimination, where you had a lot of evidence suggesting that intentional discrimination was at play or perpetuating intentional discrimination from other arenas. but where you didn't have a memo from the governing body saying, we drew these districts in order to discriminate. There's your case, nice and clean and buttoned up. And the primary example of this was a case called White versus Register in the Supreme Court in 1973. That the Fifth Circuit sort of adopted and expanded that rationale in a case called Zimmer. And all of this led to the Voting Rights Act being construed along with the Constitution relatively in lockstep, expanding the number of cases that came within its orbit to include not just blatantly intentional discrimination, but effects plus, discriminatory effects that could be tied to intentional discrimination without actually proving that one was the result of the other. Then it comes to this case David mentioned called Mobile versus Bolden in 1980, where the Supreme Court said, no, you've got this all wrong. The Constitution demands proof of intentional discrimination flat out. And Congress said, okay, that may be true for the Constitution, but that's not what we meant the Voting Rights Act to cover. And in 1982, there was a significant update of the Voting Rights Act, a real revision that said, we want the Voting Rights Act to encompass more than just intentional discrimination. We want it to encompass vote dilution, discriminatory effects with a tie to discriminatory intent that perpetuates discrimination upstream. It's not going to rely just on raw numbers of people of color or candidates of color. It's not going to just be look at the effects and that's it, you're done. But we're going to require a totality of circumstances that shows if you don't design the lines differently, you're going to be perpetuating discrimination that the states had in place. You're going to be continuing to subjugate communities of color. That was the 1982 congressional rebuke of the court, really, for getting it wrong in Mobile versus Bolden. They didn't change what the Constitution means, but they changed what the Voting Rights Act reflects on the face of the statute. And it is very clear and has been very clear to every court to approach this question since 1982, particularly when the Supreme Court picked it up again in 1986, to say Congress wanted the Voting Rights Act to address more than proof of intentional discrimination, because that proof is really, really, really hard. Because danger signs of intentional discrimination should be enough, given Congress's enumerated power, no less powerful than the Commerce Clause, no less powerful than immigration, or the power to declare war, or the power to set up a bankruptcy code, the power to enforce the 14th and 15th Amendments. Congress gets to go a little bit farther in order to prophylactically guard against intentional discrimination that's really hard to prove. That was the governing standard for 40 years up until a month ago.
Yeah, I mean, it's I think it's sometimes helpful to talk about this. One of my first of all, the 1982 reauthorization of the Voting Rights Act was passed on a bipartisan basis and signed into law by President Reagan. In 2006, it was set to expire in 2007. It was reauthorized in 2006 by Congress. For those of you who aren't aware, a lot of people on this call were probably involved in that, as I was. Justin, you were. I mean, this is that passed Congress by a vote of 98-0 in the Senate.
The same.
Go ahead.
It's the same confirmation count in the Senate as Justice Scalia's confirmation vote, 98-0 in the Senate.
Right. And as an aside, Justice Scalia used that 98-0 vote to kind of counterintuitively suggest that that itself was suspicious about Congress's intent. I don't know how you rationally get to that point, but I don't mean to speak ill of those who've passed on. And a vote of 390-33 in the House. I can't imagine many votes getting that kind of vote in the United States House. It was signed into law by President George W. Bush. I mean, Congress, there are very few places Congress is as clear about its intent as it was in its rebuke of the Mobile versus Bolden decision and its clarification of the standard that just, making racist comments on the floor of your state house the absence of that doesn't mean you don't have a claim under the Voting Rights Act, that there are ways in which discriminatory results can reasonably lead to the conclusion that intent was there. Is that a fair characterization, Justin?
Yeah, and I think that for anybody who's litigated knows that you have to establish that tie, and that's not just a one-off. That's not just pointing to things that happened 60 years ago. Tamar was talking about all of the experts that you need to deploy in order to prove that voting patterns are different, in order to prove the demography, in order to prove that the lines are the problem. You also have to deploy expert reports, historians, and social scientists to provide the context for modern day perpetuation of discrimination in areas both inside and outside of the voting process in order to win a case. And those are lengthy expert reports, not just vibes. And it
Yeah.
seems like, unfortunately, we are now back to vibes.
Yeah. Tamar, do you have any further thoughts on that? I mean, especially, I mean, the 1982 standard is kind of clarified by that 1986 case Thornburg versus Jingles that Justin's referring to, was kind of the North Star for all of us. I mean, it was really established law for so long. We didn't, up until the last couple of years, I don't think anyone could imagine, even as cases were declining, we still knew like that standard had to be met. It's getting harder and harder to meet that standard because some things are getting better. I mean, or had been in some places. Do you have any other thoughts on that, having been there?
No, the only other quick observation I would make is that this process of Justin, I think you called it intent plus or impact plus intent. That's not uncommon across civil rights statutes.
Mhm.
And so this is something that courts know how to do. It's something litigants know how to do, and it's something that until maybe now the Supreme Court knew how to do. And part of that is because, look, at the end of the day, it's discrimination that we're trying to uproot. And really, it's intentional discrimination, even if the distinction in the law is important, but it's not I, the decision maker, have in my mind at this moment to discriminate against somebody. But the intentional discrimination is never far from the surface in any of these cases. It wasn't when you did the analysis, the results analysis under Jingles, just as it isn't when you do disparate impact analyses under a variety of other civil rights statutes. And this is how it's proved. And you keep hearing us say this, but and those of you who've done this, we cannot overstate how rigorous this is, how hard it is, and at how many different stages your cases can fail. Justin talked about the history of discrimination and bringing it to the current day. It's also true that one election where a Black preferred candidate loses, and you can prove racial Black voting as to that one race, that's also not going to get you there. I mean, it is rigorous in so many ways and layered
Yeah.
in so many ways.
Yeah, it required pervasive racially polarized voting. I remember it's also true. There were places where kind of a unicorn candidate could do well, and yet you could still show pervasive racially polarized voting. I remember in Georgia, and this is still true. Sanford Bishop outperforms every black candidate in Southwest Georgia by a huge margin, and he has a unique profile as a candidate that presumably enables him to do that, and that's just not necessarily something that can translate elsewhere in what we would call exogenous elections that were not congressional elections. But it strikes me this is all, and now it's been made harder because of this. I don't want to oversimplify it. The requirement of intentional discrimination to be proved, but also this safe harbor that partisanship provides. It as we discuss kind of what this means for the near future, 2026 and maybe 2028. Maybe you both could talk about, Justin, you had a really unique view on this that I found very compelling. I don't usually say nice things about Justin, so if you're listening, take note of them. But Justin, you raised this point, and we're seeing in Louisiana and in Alabama right now, kind of the way partisanship is inoculating otherwise what might be racially discriminatory plans. Can you talk a little bit about that? Because I think it's a really unique and kind of unconstructive incentivization of partisan gerrymandering. The Supreme Court has previously said it's too hard. We can't figure out how to outlaw it. But now they've kind of in ways incentivized it.
Yeah, they certainly have, and in the worst possible way, in the most destructive possible way. So what Calais basically said is you have to take all other race neutral factors out of the equation before you can determine that something discriminated based on race. And that is exactly the provision that's going to make proof harder at every single stage of the analysis, and in some cases impossible. One of the main things that the Supreme Court said you have to take out of the equation is partisanship. And that means that the more interlocked race and party are, the more insulated you are from a race claim, because you can always claim that's not race, that's party. And that used to be a problem under constitutional doctrine. It is now an even bigger problem under the Voting Rights Act, again, inverting exactly what Congress intended. The more racist you are as a party, and the more you can drive racial splits based on party, the more insulated you are from Voting Rights Act liability. It's precisely backward. If you can imagine a Klan party openly advocating for racist policies, that's going to drive who supports and who opposes that party based on race. And that very racist policymaking is going to insulate the Klan party from any consequences under the Voting Rights Act for redistricting, because you're not going to be able to disentangle how people feel about them based on their race and how people feel about them based on their party. It's also going to incentivize parties where they can't completely eliminate partisan opposition. It's going to incentivize them to choose their tokenization, to choose which members of the opposing party they want to over-concentrate in particular districts to make them the example. And that's really weird when you think of an opposing party having the ability to brand your party simply by the choice of which voters they choose to count and which voters they don't. It is license, even if formally extreme partisan gerrymandering is still unconstitutional. The Supreme Court has basically said because it's a defense to a Voting Rights Act claim, it's licensed to engage in the worst kinds of partisan gerrymandering going forward. And just to point to what I know the next portion of our conversation will be, it's something that Congress is really going to have to fix.
Yeah, we're going to get to that in a second. We might have differing views on what it should do and whether or not it will do those things. But Tamar, I wanted to go to you too. We had a good conversation. We were talking about how this is playing out in the Alabama litigation right now. And for those of you who aren't familiar, just 3 years ago, this same 9 people on the Supreme Court upheld a lower court decision that the existing Alabama congressional district plan was a racial gerrymander, and they were required to remedy that with a second district in which Black voters would have an opportunity to elect candidates of their choice. After Calais, the Alabama legislature raced to reverse that. And just this week, as we mentioned, a 3-judge court ruled, nope, that map is intentionally racially discriminatory. And they went it to great extent. I was really struck by this, and you read it much more carefully than I did, Tamar, to the degree to which they tried to apply Calais and tried to, using all of the factors that Justin was just talking about, tried to disentangle partisanship from the racial elements. Can you talk a little bit about that?
Yeah, and I'm interested to have both you and Justin weigh in on this as well. But look, I think Alabama, the decision from I think just 2 days ago by the 3-judge court in Alabama is really interesting. I think it is a must read for anybody who is going to be litigating constitutional, probably cases, but cases also under the Voting Rights Act going forward. I think it has a lot of things that could be instructive. I also caution that it is it's unique in its posture, and it's unique for another reason that Justin suggested very early on, which is Alabama is trying now to say, this is really just partisanship. Hey, nothing else to see here. It's just partisanship. But because of the way this case has come before the courts, the court was able to look at the record and say, that's not what you said. That's not what you did. And the record doesn't support that assertion of partisanship when you drew this exact same map and tried to use it back in 2023. And so I just say that up front because while there's so much promise in some ways in this opinion, it really all goes poof when now everybody knows that from the beginning they should just say, hey, this is all about party, and they don't have to go through this rigmarole. So with that aside, one one thing, one way that the court thought about partisanship and race was to go to, they did all the things that we talked about before. They looked at intra-party races, primaries, nonpartisan races, but they also looked at academic research. And they looked at research to say, and it was very local and very fact specific. And what they said, they looked at academic studies that said, look, when you look at how Black voters in Alabama vote and the things that they believe in, the issues align with the more conservative and Republican candidates, and yet that's not how they vote. And further, there was research and studies that they pointed to that said that Black Alabama voters tell you that it is not on these other issues that they disalign with the Republican Party, but on race specific issues and on how the parties sort on the issues of race. And so I think this it starts to put the lie to the idea that look, parties have just sorted, right? Black people vote for Democrats and white people vote for Republicans. That's just party. What can we do about that? Now, I will note that the Alabama court distinguishes this from Louisiana and Calais. And so, this is going to be very local analyses, but I think this is an area that is going to be fruitful for some, really, really solid academic research going forward.
And
Yeah,
everything that Tamar just said is absolutely even more true when it comes to the various Latino and Hispanic communities and the various Asian American communities, all of which have different preferences in different locations, and even more true in local democratic structures in municipalities and the like.
yeah, that's a great point. I wanted to, I thought your point about the procedural posture of the Alabama case and how it's different is really important. There is a long established record in that case that the proponents of the new map in Alabama that is currently stayed, that is currently enjoined, can't do anything about. And that was developed under the former standard under Section 2. And so they are stuck with that to some degree, and that might help those who are challenging the map in Alabama. But uh, the really troubling aspect of the Calais case, in my mind, and it reminded me of U.S. versus Trump, the immunity case, in the same way. They're not on the same areas of law at all, but it is a roadmap to bad actors in the future and how to cover their tracks. And Tamar, you touched on this point. Anyone reading the Calais case, and you can see this play out in Tennessee and in South Carolina, and in Louisiana. They're using this as a roadmap to cover their tracks if they are engaged in racial gerrymandering, in a way that will not be as challengeable as we're seeing in Alabama. And similarly with the immunity decision, the reason it came to my mind when I saw that is the immunity decision case didn't necessarily derail that prosecution. What derailed that prosecution was that time was running out until the next presidential election. I mean, if Donald Trump had lost the 2024 election, that might still be going on under a standard that was established. What was really troubling about that was it created, and we're seeing this play out right now, a roadmap for a president who wanted to be a bad actor to inoculate himself against future criminal prosecution, by jumping through some very simple hoops that Chief Justice Roberts laid out very clearly in that, as Justice Alito does here. We've got 8 minutes, and I want to get back to the point where I promised you we would get back to, Justin, which is, okay, we are where we are. What could Congress do about this? And then we'll get to the second part, which might not be as fun, which is, will Congress do that?
So even before we get to what Congress will do, in 20 seconds, I just want to say the Voting Rights Act is not the only claim that deals with the use of race in the redistricting process. There are still going to be Shaw-like claims. There are still going to be intentional discrimination claims. And so, as upset as I am by how this construed the Voting Rights Act, I don't want to imply that it's sort of free reign for line drawers to do whatever they wish with minority communities. There is still a robust jurisprudence about intentional discrimination. In fact, that's where the Alabama court has landed. From 527 pages 2 years ago, try as we might, we cannot understand the 2023 plan as anything other than an intentional effort to dilute Black Americans' voting strength. And those cases are still going to be available. You're going to see a lot more of them now because the Voting Rights Act got so much harder to prove. For now, I think that the American people have a real distaste for unfair process. And I think you see this in fighting back against partisan gerrymandering. I think you see this with some of what they perceive to be problems in the campaign finance system. I think that democracy is coming on the ballot in ways that are far more salient now. And I think that the American people still get to, believe it or not, instruct their representatives when they really care about something enough. I think that voting rights are going to be a principal issue this year, this fall. I think they're going to be a principal issue heading into 2028. And there is still plenty that Congress can and really should do. Those range from the modest to the very aggressive. Modest, ban mid-decade gerrymandering. Could do that tomorrow. You could, as Congress has done in the past, take steps against partisan gerrymandering and take away this giant excuse for legislators to do what they want with massive impacts on race in ways that hide true racial discrimination. Congress could fix that by limiting or eliminating partisan gerrymandering as well, not just for Congress, but for state legislative races. There are even more aggressive solutions, things like proportional representation that are going to be a long time coming to Congress if they don't come to states first. Things like expanding the House, things like restoring the Voting Rights Act in all of its former glory, because all of the decisions that we've seen so far are really statutory interpretation cases. Shelby County, statutory interpretation case, Calais, statutory interpretation case, and if Congress wanted to, it could rewrite the statute to say, no, I'm sorry, Supreme Court, you were wrong. In order to do that, they're also going to have to embrace court reform because this court has shown that it doesn't care what Congress says. And so Congress is going to have to remind the court to care about what Congress says.
So I am going to, first of all, I love your optimism. I share a segment of it, which I won't elaborate upon. But I do want to point out this point about Congress fixing what the Supreme Court has done is not a pipe dream. That happened in 2006. In 2006, they altered the Voting Rights Act slightly to address a decision in Georgia versus Ashcroft, which I know very well because I happen to have been lead counsel in that case. It's a decision we won in the lower court, in the Supreme Court by a 5-4 margin. The Supreme Court basically said what were called coalition districts. I don't really like that term very much, but districts in which minorities didn't make up 50% plus one in a district, but banded together with others, including white voters, to consistently be able to elect candidates of their choice, that somehow wasn't contemplated by Section 5 so much. And Congress said, oh, no, 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 no. Yes, it is. That's fine. I'm paraphrasing this very much. But Congress has done this. They did this after the Mobile versus Bolden decision in 82. They did this after Georgia versus Ashcroft in 2006. They can and should do this. I think the only part where I hope you're right, but I might be less optimistic is whether they will. They will adopt some of these things. Congress is. I don't know that a 98-0 vote is possible even to name a post office now.
It's going to take the American people caring and making it a frontline ballot issue for Congress to act on this. There's no question that they're going to need to be pushed. But my sense of the electorate is the electorate's getting in more of a mood to push.
So can I go? We're not going to have much time for questions. There was a question here that I thought was really interesting that I've seen you comment on, Justin, and I'd love to hear your thoughts, and Tamar chime in as well, which is, can state Voting Rights Act somehow moderate the negative impacts of this decision? Justin, you want to start?
A bit. And I will say that states can, on their own, prohibit partisan gerrymandering. Several states have. That also, as we were talking about Congress doing, that helps establish the conditions where the Voting Rights Act, even after Calais, can be effective. States have also passed decisions, statutes that are their state-based Voting Rights Act, not about partisan gerrymandering, but about racial equity and making sure prohibiting racial discrimination. And yes, states have different authorities to pass those statutes than Congress has to pass something like the Voting Rights Act, and far more latitude, I think. There's no question that people will interpret or misinterpret the language in Calais to bring challenges to those state voting rights acts. It's already happened in Illinois. It's going to happen elsewhere. But I like the chances a little bit more.
That's really good. Tamar, do you have any thoughts about that as well? Go ahead.
Nothing to that. Yeah.
Well, one thing, Justin, I wanted in the last couple of minutes, one of the things I think a lot of people are concerned about right now is that a lot of the states that have passed laws with regard to minimizing or limiting partisan gerrymandering or passing their own state voting rights act tend to be states that are run by Democrats, and a lot of Republicans haven't. And what we're seeing play out is that Democrats might now perceive that they unilaterally disarmed in this race and they have fewer tools available to them. And especially if they want to create an incentive structure to bring both parties to the table, it's actually a disincentive to pass some of these things. I don't know if either of you have quick thoughts on that.
I think it gets worse before it gets better. I think we're going to see more dysfunction before we see function. But I think it's really significant, even as the electorate in California and the electorate in Virginia tried to temporarily undo some of their state processes to fight against partisan gerrymandering. They didn't touch the processes for state legislature. And what that means is the voters still like it. They perceive what they're doing as a necessary response to some partisan excess elsewhere. And so they're willing to take that step for a necessary response. But voters still respond. And it's not just Democrats. Look at Utah and the massive outcry that the voters in Utah have had against an abuse of power by the legislature. Voters are fed up across the board, I think.
Yeah, I'll just say quickly, I want to say a pessimistic thing than an optimistic thing. The pessimistic thing is I think voters in California and Virginia, California is going to be in place for 2026 with regard to congressional races. The Virginia decision is likely only going to affect 2026. I fully expect we're going to see new district lines for Congress in 2028 there. And I think in a lot of Democratic states, I think Illinois, New York, every place is fair game. California might re-redistrict. And California specifically kept their process in place, but I think that could be very much at risk, a process that you and I know very well. That said, I do think there is another big point of hope, which is that the voters are going to have a say, and that all of these plans by cynical partisans, not necessarily just on one side of the aisle, to maintain or increase their political power, are based on past voting behavior and past voting turnout. And the highest turnout we have ever seen in a modern midterm election is 50% in 2018. We had 46% in 2022, which is considered very high. If we have 53, 54, 55, 56% in 2026, all of these plans go out the window. And I actually am optimistic. I think we're going to get to that level. I think we're going to see historic turnout. And we're going to see all of these plans by politicians to pick their voters upset by voters saying, And I think the best thing we can do as individual citizens, and I've seen some questions along these lines, drive turnout out as high as we can. By the way, I think we should drive turnout for people that we might politically disagree with as much as we can. Find 50 voters, including 10 people that don't agree with you in other states, to go vote. I think that's going to be the antidote to all this. Ultimately, back to your original point, Justin. I don't know if either of you want to have the last word as we're a minute over. Okay. Well, thank you. Thank you all for joining. Thank you two for both being on with me. This was, we've had multiple conversations about this, and it's always interesting to me. And thank you all for joining. We'll host these regularly. Hope you'll join us for other topical webinars on these kinds of issues. And again, big lesson from here, everyone. Go recruit 50 people who might not otherwise vote, and make some of them people you disagree with politically, and get them turning out. Thanks, everyone. We'll talk to you soon.
Thanks, David. Thanks, Justin.